I'm Jutta Brunnée. I'm the Dean of the University of Toronto Faculty of Law, and I want to begin by acknowledging this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. Today, this meeting place is still the home to many Indigenous peoples from across Turtle Island, and we are grateful to have the opportunity to work and learn on this land. I'm delighted to welcome everyone to this webinar on the Notwithstanding Clause. I want to begin by thanking Brenda Cosman, the chair of our Research Advisory Committee, in organizing behind the scenes the program that we'll be enjoying in the next hour, and also all of my colleagues who are here for stepping in on relatively short notice to give their perspectives on a topic of considerable current interest. Now, as you will all know, there's been a lot of talk about the Notwithstanding Clause, most recently generated by the Ontario government's back to work legislation that involved preemptive use of the clause. And what we want to do is explore this particular usage of the Notwithstanding Clause, but then zoom out to what seems to be a pattern of increasing recourse to the Notwithstanding Clause, or at least mulling over as to whether or not one would resort to it, and then to take a look at slightly bigger picture issues as to what that all means for the relationship between courts, legislatures, the charter rights, and so on. Now, we have 7 speakers. They each will be strictly speaking, sticking to 7 minutes. So I will be extremely brief and will launch us into the conversation by turning over the floor, so to speak, the virtual floor, to our first speaker. That is Nathalie de Rosiers, who's the principal of Massey College and also cross-appointed to the Faculty of Law. Nathalie, the floor is yours.
Thank you. Notwithstanding unions, quotation mark, that's my title. The first time that the Ford government introduced the Notwithstanding Clause in 2018, MPP Doug Downey, who is now the Attorney General of Ontario, responded rather flippantly to the argument that the drafters of the Charter had not intended for it to be used preemptively by saying, the Constitution is a living tree. Constitutional interpretation must evolve over time. And certainly, as a Professor Bédard-Rubin will argue, the Quebec government has used it in a larger context of a political affirmation of Quebec's cultural distinctiveness. But how does the Notwithstanding Clause in Bill 28, the bill that precipitated our discussion today, the Keeping the Students in Class Act, fit with the Ford government's political objectives? So why use the clause, and was it necessary? First, let me posit that as many populists, the Ford government is engaged in a program of trying to remove some of these old rules, which to his mind gave too much authority to elites, particularly lawyers, judges, courts. It's also about reducing the powers of the public sector unions because they prevent government to act as they wish. For governments like Ford, constraints, legal or financial, imposed by non-elected people are seen as suspicious and potentially illegitimate. Indeed, much of the legislation routinely eliminates the right to recover damages from the government, imposes procedural rules to sue the government, and it is the 3rd time that the Ford government has used the Notwithstanding Clause. On crushing public sector unions, we should remember that the cousin of Bill 128 is Bill 124, which limits salary increases to 1% a year throughout the public sector at the time of raging inflation. Needless to say, this bill is in front of the courts now. Now, Bill 28 is a cousin of Bill 124, but it goes much further. It is a brutal attack on labor rights. It imposes salary and working conditions for 4 years, eliminates the right to strike for 4 years, does not provide an impartial and fair mechanism to resolve disputes or deadlock in negotiation. It curtails the ability of the Ontario Labour Relations Board to take the Constitution into account. We haven't discussed that very much, but that was interesting. And the penalties for violating the Act are draconian. They are indeed more expensive than the penalties imposed on lawyers after a 4-month strike in Quebec. And we're talking here about support staff in schools. So it is clear that Bill 28 violated the charter. It is clear, I think, to me, that there was very little attempt to trying to save the provisions under Section 1. Indeed, not much heed was put on some of the courts that say there could be possible limits. All of this was ignored. So it does beg the question, though, is it possible to have back to work without violating the charter? Do government will have to use a notwithstanding clause to end strikes by legislation? Can a back to work statute ever be saved by Section 1? And I believe it can. I think even though freedom of association, which protects the right to strike, the right to meaningful collective bargaining, is relatively young, first breakthrough in 2008, and the second one in 2015, the courts are starting to provide guidance to legislators. And indeed, let me just say 4 quick points. There is language about deference to a government in deciding when there is a deadlock. There is no deadline on how long a strike could last, but certainly the length of a strike, its impact on the public will be taken into consideration, just as much as the history of negotiation. It will be very much a contextual, factually driven approach. The provision of a fair and impartial mechanism must be done and cannot be restricted. It must be available for all the questions that are at issue between the parties. And as Justice Morissette of the Quebec Court of Appeal just said recently, negotiations must take place and they must be in good faith, even if it is painful. So the purpose of the freedom of association is to try to maintain a sense of equality between the parties, the union and the government, so they negotiate freely and fairly. It's very difficult for government to accept that because it requires some form of humility about the process, but that's what they must do and that's what they must learn to do. So let me conclude briefly on 2 points. The problem with preemptive use of the notwithstanding clause is because it shuts down judicial deliberations and debates about the scope of Section 1 and how to translate the laudable goal of freedom of association into the realities of the variety of labor disputes that we have and will have in our society. And second, the Ford government's goal have been to reduce the role of law, lawyers, and courts in the management of public policy and to curtail the power of public sector union. Interestingly, we might conclude that in his attempt to do the former, it may have emboldened and empowered the latter, and that could be positive for the future of labor law. Merci. Thank you.
Thank you so much, Nathalie. You got us off with a bang, and I'll go from here straight away to Kerry Rittich, who's a professor of law and also of women and gender studies, and she writes on the law of work and all manner of things related to that. So Kerry, please.
Thank you, Jutta. Let me just pick up where Nathalie left off and just make a couple of observations about the constitutional context here. Constitutional labor rights have always been quite contested terrain, and that's true in the courts as well as in the legislature. The right to strike is exemplary here. Constitutional recognition in Canada is quite recent, only 2015, and so is the right to bargain itself. After it was initially recognized by the Supreme Court of Canada in 2007, dissenting judges attempted to significantly roll back its recognition in 2011, even though it wasn't argued. And its constitutional status was only and perhaps just provisionally stabilized again in 2015. In my view, given this constitutional context, it's not surprising that the notwithstanding clause would be invoked at some point in respect of a labor dispute. We'll put aside whether or not this was a well-considered occasion on which to do so, given that the government was facing big contracts across the sector that were up for renewal after 3 years of wage restraint. And of course, the legislation imposed a contract on the very lowest paid educational workers, the educational assistants and the maintenance workers, many of whom who were women. As Nathalie mentioned, the legislation precluded the use of the strike weapon on pain of an extraordinarily large penalty, but workers did in fact go off the job. The province immediately went to the Labor Board for a declaration of an illegal strike, cease and desist order, a back to work order. And as everybody knows, they clamped down in relatively short order and withdrew the application before the board. Nonetheless, I think it's worth considering what's at stake had the application gone ahead, what's at stake for the workers, for the board, for the government, and in fact, for the rest of us. The union correctly argued that this was a political strike, but it's important to notice that this is not normally a defense to a strike. It's not historically protected in Ontario, so the workers took a real risk here. The more fundamental issue is perhaps what remedy the board would or should order in a case like this. Because one way to understand the use of the notwithstanding clause in this context was that it was a declaration on the part of the government that it views the labor dispute as no longer a legal or a constitutional issue at all, purely a political one. But having made this decision, should the government then be permitted to use labor legislation for its own purposes to get workers back to work, while simultaneously precluding the workers from the protections that the legislation and the charter normally provides? At minimum, this is highly distasteful for the board. Arguably, it's an existential, that's to say a political question for the board. Any board is going to prefer not to make such an order. It might well refuse and will certainly seek every alternative. I have to observe that the Globe and Mail itself observed that the use of the clause throws a nuclear bomb into collective bargaining as a whole. And I think it's worth noticing how much constitutional latitude the government already has. The constitutional right to bargain is quite minimal in what it protects. It's not the right to have any particular demand met. It's just the right to a process, and that process itself is pretty minimal. The parties have to meet and engage in meaningful dialogue. In general, the subject of negotiations isn't subject to scrutiny, and the governments may well be able to take wages out of bargaining. What about the right to strike? Recognized as the powerhouse of collective bargaining by Justice Abella. It too has always been hedged with limits, international law as well as domestic law. For example, where the interruption of services might endanger life, safety, or health of the population. So there is, of course, a way to deal with strikes ex ante. You can designate workers as essential. But for those designations to be constitutionally valid, we have to be talking about more than mere inconvenience. It's got to be serious harm, and the limitations themselves have to be circumscribed. Where strikes are precluded, as Nathalie mentioned, the affected workers have to have some alternative means to resolve bargaining deadlocks. And at this point, there is going to be some third party involved. Why? It's worth rehearsing this, even though it's very, very basic. Conflicts over the terms of the contract are an old, not a new problem. This is precisely why we have well elaborated norms, institutions, and practices for doing so. This is effectively why collective bargaining exists. Let me just wrap up by observing that it's not hard to understand why the other side, by which I mean the labor movement as a whole, would understand the attempt to preclude judicial review as a declaration of war. For example, if it were to be successful, would it be extended to teachers as well, healthcare workers, the broader public sector? perhaps even the private sector. I think the question would be, why not? We should expect it, and the unions clearly did. The Ford government may not have intended an all-out across-the-board war on unions. I will not attempt to answer that. But I think by not foreseeing what was a quite predictable response, they showed lamentable ignorance, both of labor history and how collective bargaining works. You will get a strike in circumstances like this, legal or not, and the consequences of that strike will spill over. This is, in fact, why we have had collective bargaining legislation in the first place. In my opinion, we've just had, the last word here, a brief demonstration in Canada about the enduring connection between collective bargaining law and political democracy, something that has receded in collective consciousness, I think. Ruth Jukes and Wolfgang Streich have just released a wonderful book on this connection that I will commend to everybody. But they say, rightly so, that collective bargaining is crucial to stabilizing and legitimizing political democracy as a whole.
Thank you so much, Kerry, for putting, I think, front and center what's at stake here and reinforcing, building on what Nathalie had done, and that is the importance of collective bargaining in particular. So we'll now move from the issues in Ontario a little bit further to consider other examples, and I will give the floor to Jean-Christophe Bédard-Rubin, who is an assistant professor at the Faculty of Law, whose research focuses on Canadian constitutional culture, including from a comparative perspective.
Thanks for the introduction, Jutta. Very happy to be part of this panel. I would like to say a couple of words briefly about Quebec's experience with the Notwithstanding clause in the last couple of years, especially since 2018, when the Coalition for the Future of Quebec, or CAQ, was elected to form the government. So there are two important and salient examples that come to mind when we talk about the Notwithstanding clause in that context. The first is Bill 21, or the Act Respecting the Laicity of the State, and Bill 96, an act respecting French, the common and official language of Quebec, a comprehensive reform of the Charter of the French language, known as Bill 101. So the Notwithstanding clause was used preemptively in both instances, to the dismay of many opposing the measures. And I don't want to talk specifically about the merits or defects of both legislation, but I would like just to suggest some caution in interpreting what Quebec has done and what Ontario has done recently. And instead of seeing perhaps one general Canadian trend, or the two provinces partaking in the same democratic backsliding or rejection of liberal constitutional norms, to suggest that there might be other more domestic factors at play. And in Quebec in particular, it's rather the conclusion of a constitutional chapter rather than the opening of a new one. So it's important to realize that the CAQ's political positioning is reminiscent of the Liberal Party's position in the 1970s and 80s. It is a center-right federalist party with a nationalist bent, seeking to enshrine Quebec's difference within the Canadian Constitution. And if it's necessary sometime to use the Notwithstanding clause, they will do it just like the Liberals did it on 12 occasions between 1985 and 1994. But more importantly, what the CAQ picks up from the Liberals' playbook of Robert Bourassa in the 1980s and 90s is seeking to entrench an interpretive clause in the Constitution. So this was the case in the Meech Lake Accord and later in the Charlottetown Accord. So I'll read just to remind our audience, perhaps who don't have this in mind, that the Meech Lake Accord provided that the Constitution of Canada shall be interpreted in a manner consistent with the recognition that Quebec constitutes within Canada a distinct society, and the role of the Quebec legislature and government to preserve and promote the distinct identity of Quebec, referred to in paragraph 1b. So while this might seem like a piece of constitutional trivia, it has been memorialized in some way in Quebec, sometimes with the help of politicians and academics, and a general sense that the Canadian jurisprudence is either too Anglo-centric or hostile to Quebec difference is sometimes exemplified by the rejection of this distinct society clause. So let me explain how this plays out in justification for Bill 21 and Bill 96. So Bill 21, adopted in 2018, was not presented initially as a rejection of liberal constitutional norm or as an illiberal proposal. On the contrary, the government put heavy reliance on the jurisprudence of the European Court of Human Rights to justify what could be presented as somewhat modest restrictions by Western European standards on the display of religious symbols for public employees. After all, Quebec's position is closer to Germany, Belgium, and Switzerland than it is to France's strict laïcité on one end of the spectrum, or the UK's more liberal stance at the other end of the spectrum. And the ECHR, so the European Court of Human Rights, accepts almost all of those positions along that spectrum. So reliance on this international jurisprudence was meant to underscore that Quebec was not rejecting rights as such, but looking for other deliberative partners, perhaps more accepting of legislative activism in other civilian countries in determining the respective scope of each rights when they intersect. So by doing this, the Quebec government was also suggesting a certain interpretive stance, apparently forbidden in Canadian courts. As part of a diverse federation, the Supreme Court of Canada should adopt a similarly deferential approach or leave some margin of appreciation to the members of the federation. For example, how to regulate the relationship between church and state. In other words, this means for the Quebec government in that case, that the Supreme Court of Canada should take into consideration the fact that Quebec is the only historically majority Catholic province, that given its control over immigration issues to a larger extent than the rest of Canada, that integration issues are not the same, and that the situation of French and English cannot be treated symmetrically across the country. The question is, however, why does one need a notwithstanding clause to achieve this? Why can't the Attorney General simply rely on those facts to make the case that, given the flexibility afforded by the proportionality analysis under Section 1, these cases can be successfully defended in court, and Quebec could defend the validity of its legislation? Why not take into account, for example, the recognition of Quebec deference in the jurisprudence of the court itself in Ford, but also in the Supreme Court reference in 2014? This brings me back to the Meech Lake Accord, and more generally to the Meech Lake era, because Bill 96, so the other important piece of legislation, not only reformed the Charter of the French language, it also introduced a constitutional amendment, an amendment to the Quebec Constitution part of the Constitution Act 1867. And Quebec has promoted those amendments by printing these little booklets here, which is an administrative codification of what now reads as Section 90Q1, Quebecers form a nation, and 90Q2, French shall be the only official language of Quebec. It is also the common language of the Quebec nation. Now, of course, these provisions are a reminder of the failure of the Meech Lake Accord and a similar interpretive clause entrenched in the Canadian Constitution. And though it has been disputed by constitutional scholars, the Minister of Justice of Quebec nevertheless argues that this will tilt the balance in the future in the interpretation of rights and freedoms. While this assumption might have seemed reasonable in 1987 that the addition of an interpretive clause would make a big difference in charter litigation, I think that 35 years of charter litigation suggests that this is probably an overstatement. After all, interpretive clauses have played quite a modest role, including, for example, Section 27 on multiculturalism. So again, why is this interpretive clause necessary? What difference will it make in practice? And why can the Attorney General of Quebec simply argue for Quebec difference in court in trying to justify its piece of legislation? So I think that we should understand that the CAQ might have a bigger endgame in mind than achieving specific judicial victories. So when Bill 96 was tabled in 2021, there was a Léger poll that was released and showed that 78% of Quebecers thought that Quebec should sign the Constitution Act 1982 if those two provisions were adopted and accepted by the rest of Canada. So Bill 21 and Bill 96 may seem somewhat clumsy or unfortunate legislative exercises for some, but I think that they should be understood first and foremost as an effort to bring the constitutional chapter that was opened by the Meech Lake Accord to an end rather than opening a new illiberal one.
Thank you so much, Jean-Christophe. Perfect timing and lots to chew on. And we'll go from Jean-Christophe to Professor David Schneiderman, Professor of Law and Political Science. He's an authority on Canadian federalism, the Charter, and Canadian constitutional history. And so perhaps not surprising that he will talk to us about the Notwithstanding Clause intentions and application. David.
Thank you, Dean Brunnée. It's a pleasure to be here with colleagues. So the object of this little talk is to talk about origins and applications of the Notwithstanding Clause. And typically we don't look to origins in constitutional interpretation in Canada, but nevertheless, I think it's instructive, particularly from a comparative constitutional law point of view, because it turns out that the US was the anti-model that served to help to rationalize the inclusion of the Notwithstanding Clause at the time. And for many of the relevant actors, it's that US experience, the negative part of the US experience, that served to justify inclusion of the Notwithstanding Clause. So the source for my little talk of original intentions is a text of a speech that former Premier of Alberta, Peter Lougheed, gave in 1991 entitled "Why a Notwithstanding Clause?" ? And Lougheed explained that it was the US experience during the Lochner era that convinced premiers to include a legislative override. Now, the audience may recall that in the Lochner era, the dominant judicial approach in the United States was to limit legislative intrusions into the marketplace by both state and federal authorities. In the Lochner case itself, it was a New York state law that limited hours of work at overheated bakeries. And in other instances, state legislation mandating, for instance, minimum wages, or federal law prohibiting the movement of products that were produced by child labor, so prohibiting that movement, were declared inconsistent with the 5th and 14th Amendments to the US Constitution. So it's this constitutional experience, when the judiciary in the United States held fast to an ideology that stalled legislative innovations to protect vulnerable workers, that, Lougheed says, inspired the premiers to include Section 33 in the Charter. It was the, quote, American experience, he said, in the legislature that inspired Section 33, when judicial interpretation was, quote, fundamentally different from the view of legislators. And it's important to know that other relevant political actors, like Premier Alan Blakeney of Saskatchewan and Attorney General Roy McMurtry, identified similar motivations for including Section 33. It's in regard to matters of major public policy thwarted by courts that would justify invocation of Section 33. It's important, though, to place Lochner within its historical context. Judges were doing in the Lochner era what was expected of them. For sure, there were exceptions, Justices Harlan and Holmes, but the preferences they channeled were not outside the judicial mainstream, but well within it. It was only when the electorate demanded that political branches take on new functions that rubbed against these entrenched interests and the thinking of the legal establishment that tensions arose. So in other words, it was a generational shift that gave rise to this lamentable period in US constitutional history. So if this is accurate, the Notwithstanding Clause was meant to be available only in unique periods of transition, when dominant legal thinking, what we teach here at the law school today, does not line up well with the legislative agenda desired by large swaths of the electorate. Because no constitutional system could be expected to survive through periods of prolonged dissonance, one expects such moments to be rare. And of course, the Notwithstanding Clause has not been confined to these moments of misalignments. Many contemporary uses do not exhibit the sort of circumstances contemplated by the premiers in 1980, including preemptive uses that we're talking about in Ontario. So while there certainly have been abuses of the clause, I think an early episode is instructive, and I want to remind the audience about attempted use of the clause by Premier Ralph Klein to place a cap on damages available to victims of forced sterilization. It was in the period 1928 to 1972 that Alberta pursued this policy of eugenics. And the override was used to limit liability available to the victims of forced sterilization. The minister declared at the time that it was to ensure that, quote, historical claims be settled expeditiously and without requiring a prolonged constitutional debate with the associated time and expense, end of quote. The stench associated with this usage solely for administrative convenience and against a historically disadvantaged group caused such a furor in the province that Premier Klein backtracked within 24 hours of announcement of the bill. I'm going to skip over the Vriend episode where Premier Klein also threatened to use the notwithstanding clause, but he too decided to not invoke it in response to the Supreme Court of Canada decision, having been flooded with correspondence that, quote, made his stomach turn. One could say that in these instances, the clause worked rather well. Governments were shamed into retreating from their use in circumstances where already vulnerable communities were being targeted by government. And the same could be said about Ontario's Keeping Students in Class Act. CUPE membership on strike were the lowest paid employees in the education sector, a preponderance of whom were women. Premier Ford was confronted with both public opinion polling that was decidedly against the use of the notwithstanding clause, and also faced a reinvigorated labor movement that was threatening a general strike the following Monday. So Ford's breathtaking retreat is another instance where the structure of the clause imposing, for instance, transparency and publicity helped to mobilize opposition to the government's disgraceful behavior. Let me conclude by drawing out two interlocking lessons from these episodes. First, the clause should be confined only to those occasions where the judiciary are so out of step with important socioeconomic policy that they obstruct the achievement of social change through law. And second, extrapolating from the record I've described and also Supreme Court jurisprudence, it would not be appropriate to use the clause to further disadvantage a historically disadvantaged group. It should not be used to single out for special treatment minorities who are already vulnerable to the economic and political power of the majority. It's interesting, of course, that in the two instances that Jean-Christophe talked about, we might be able to forestall override, both in the case of Bill 21 in regard to the use of the availability of Section 28 to override the override, which the Quebec Court of Appeal, I think, mistakenly interpreted in its decision regarding the interlocutory injunction. And secondly, it's likely the case, it seems to me, that aspects of Bill 96 also will be thwarted by provisions in the Constitution Act 1867. Thanks.
Thank you so much, David, for this historical contextualization and leading to some very concrete propositions. And from here, we'll go to Professor Emerita Lorraine Weinrib, who's also an expert on constitutional law and the Charter and constitutional litigation. Lorraine, please.
Thank you, Jutta. The Charter project embodied Canada's particular response to the revolutionary reconception of democracy at the end of World War II. Rights-based democracy rejected older, discredited ideas of legislative supremacy and majority rule as the sum total of a democratic engagement. It predicated the legitimacy of democratic governance on the judicial protection of fundamental rights, having the status of supreme or higher law. So democracy was predicated on the idea that everyone would have fundamental rights in order to be able to participate on an even playing field in the democratic process. Section 33 of the Charter embodied one of the final compromises that enabled the Charter's enactment. But what we seem to be a little bit confused about now is the category of constitutional expression that is appropriate to understanding Section 33. Increasingly, we see governments considering Section 33 as a plenary power. But as I read the text, and I had a very tiny role in some of the drafting of the text of my former life as a lawyer in the Ontario government, Section 33 stands as an exception to the whole apparatus of guaranteeing rights and creating an adjudicative structure for litigating those rights, all sorts of sections that deal with interpretation of the rights, access to the courts, just and reasonable remedies. Right off the bat, Quebec used Section 33 to express its outrage and consternation at the adoption of the Charter and indeed of the whole package of 1982 amendments without Quebec's consent. Maximal use meant it overrode every right in every statute. I'll speak about the litigation of that case in a moment, but right now, I just want to say that after that sort of explosive use of Section 33, very, very early in the Charter's operation, the clause more or less fell into disuse and discredit. But more recently, Ontario and Quebec, for different reasons, have chosen to treat Section 33, as I mentioned, as an unfettered plenary power to preempt the Charter guarantees to which it applies. The other way of looking at Section 33 is to read its text carefully in the context of the Charter as a whole, particularly what we call the general sections, sort of interpretive and structural sections, in terms of our written and unwritten constitutional principles, and the pre-Charter protection of rights, weak as it was, but the weak majority protection of rights often produced occasional majority judgments that did protect rights, and also luminous dissents that we now look back on very favorably. I'd also like to mention that the rights limitations elements of the Charter were created not by politicians, not by federal provincial deliberations, but in the Special Joint Committee of the Senate and House of Commons in 1980-81, with the strongest support of Canadians that one could imagine in every province. And the override was the work of the premiers based on the continuity of legislative supremacy, and they stressed legislative accountability, political accountability, and that there was not very much support for the provincial premiers' opposition to the Charter and insistence on the notwithstanding clause. We know that because when the very strong Charter left the Joint Committee and went back to federal provincial negotiations, Trudeau offered a referendum on the strong Charter, being quite confident because of the strong polling that the Charter's popularity would carry the referendum in the federal government's favor. And this is at the point at which the provincial governments put forward the notwithstanding clause. And the little polling I've seen reference to in terms of the notwithstanding clause was very low. So we have a lot of sort of integrity and legitimacy in terms of the Joint Committee's work, in contrast to the proposal of the notwithstanding clause. we have one ruling in this early Quebec case that I mentioned that is important. As it happens, I represented Ontario in that litigation, and I was as an intervener, and I put forward alone the argument that the override couldn't be used retroactively, which was one of the elements of the way Quebec had used it. It was a very difficult argument to make in the court because the judges seemed to be appalled at the idea they would have an increased workload when they were already sort of completely at sea with the number of charter cases coming forward. And the prospect of having to judicially review the notwithstanding clause was not an appealing prospect for them. The court rejected two of my arguments, which I'll refer to a little bit later. But my argument that there could not be retroactive.
Lorraine, I'm just going to jump in for 1 second and say we're at 7 minutes and we have two more speakers to go. So final arguments.
Right. Okay. So the retroactivity argument was sustained. I think that there are all sorts of other arguments that can be made based on constitutional principles, on the constitutional text, but the main and the other rights, and of course the supremacy of Section 28 over Section 33. The main problem we have now is we seem to have an assumption that the notwithstanding clause is a plenary power rather than a constrained power. So I invite people to think about the way our whole constitutional history, our constitutional principles, and the constitutional text itself militate against that view.
That is a very powerful closing line. Thank you, Lorraine. Gives us a lot to think about, and I think really neatly encapsulates what's at stake here. So from Lorraine Weinrib, we'll go to Robert Sharpe, who was until 2020 a judge on the Ontario Court of Appeal. He's now a distinguished jurist in residence with us, which is a kind of homecoming because he used to be a law professor and also dean of the faculty. Bob, please.
Thank you very much. My topic is, can the courts control the use of the notwithstanding clause? The case that Lorraine just mentioned, the Supreme Court of Canada's decision in the Ford case in 1988, upholding Quebec's omnibus use of the override, suggests that the answer to that question must be no. And control since that decision has essentially been left to the political process. As a result of the Ford government's climb down that others have talked about in face of massive opposition to the CUPE back to work legislation, we've seen that political opinion can be indeed an effective control. But the question remains, is there any hope of relief from the courts? And my comments are really totally borrowed from and based upon two recent articles in the University of Toronto Law Journal. One by Gregoire Weber, Notwithstanding Rights Review or Remedy, and the other by Robert Leckie and Eric Mendelson, The Notwithstanding Clause, Legislatures, Courts, and the Executive, volume 71 and 72. And essentially what these articles argue for is that the text of the Section 33 allows the override to work in that it protects the protected law will operate without judicial interference, but at the same time holds that a judicial ruling on charter compliance during the 5-year override period is not precluded. And that, of course, provides a partial response to the plea that Section 33 should not be invoked preemptively. Now, you wonder why there are two articles. The fact is the two authors disagree on a theoretical point, and that's why there are two articles. But I think you can still read those articles together as providing the essentials for what I think a court might well consider. And the argument really is based on a close textual reading of Section 33, focusing on the words operate and operation, reinforced by a purposive interpretation of the democratic check that is built into Section 33. Let me explain. The Weber article reviews the case law and literature around Section 33 and reveals a rather casual and inconsistent interpretation of that provision. Some writers seem to say that Section 33 nullifies charter rights. Others seem to say that Section 33 removes the right to judicial review. But if you actually look at Section 33, it says nothing about nullifying rights or removing judicial review. It simply says that the protected law will operate notwithstanding the fact that it's inconsistent with a charter right. Leckie adds an important gloss on this, and that is based on the other parts of Section 33, and that is the 5-year sunset clause and the provision that allows that sunset clause to be renewed. Obviously, 5 years is the period when there will have been an election, so it'll be a new legislature or a new parliament. Leckie argues that judicial review of legislation protected, its operation being protected by the override, would facilitate the democratic check that is found in Section 33. For democracy to work properly, the public has to be fully informed. And he says, consistent with the text and purpose of Section 33, that the government's claim that the law does not infringe a charter right, or that there's some other overriding interest that requires overriding a charter right, should be met with a court ruling setting out precisely what the nature and the scope of the charter right is, so that an informed public can decide when it comes time for renewal. Now, this strikes me, these two articles strike me as a quite plausible argument in support of the proposition that the courts could judicially review a law protected by a Section 33 declaration, on the understanding, of course, that that review will not affect the operation of the law as long as the declaration survives under the 5-year sunset clause. I think the more difficult question is, will the courts do that? Because we do here encounter the possible hurdle of judicial discretion. Asking a court to make a ruling that will have no immediate concrete effect confronts a recognized feature of constitutional adjudication, often called the passive virtues, doctrines that give judges a discretion to decline to rule on moot cases, cases that are not ripe for adjudication, cases that raise hypothetical questions, cases where judicial decision will not produce an immediate result. So that's the challenge. Now, the argument was made in the Bill 21 case before the Quebec Superior Court. That case is about to go before the Quebec Court of Appeal and quite possibly will go before the Supreme Court. In that case, the trial judge tacitly accepted the argument that he could review the Bill 21's charter compliance, but he declined to do so because he said it was theoretical. And one can understand, given the politically charged nature of Bill 21, it's not perhaps surprising that he decided to dodge the question on discretionary grounds. Now, many cases, and I think the QP case is one, the government more or less concedes that its law is not protected the protected law does violate a charter right, and asserts that other considerations, keep the kids in school, should prevail. Those cases, and in those cases, a court ruling won't tell us much that we don't already know. Bill 21 might be different. As Jean-Christophe has explained, the Legault government asserts that Bill 21 is consistent with religious freedom and equality, relying heavily on a French or European-inspired idea of laïcité. Now, I think we have to accept that Bill 33 allows Quebec to make Bill 21 operative in the name of that vision of religious freedom or equality. But the question I ask is this: should the Quebec government, relying on that contested vision, be allowed to preempt a court ruling explaining to the public the Charter's different vision of those rights so that the voters can make an informed decision? Allowing judicial review despite the override would be consistent with the text and the purpose of Section 33 and would amount to a significant but partial response to the plea that the override should not be invoked preemptively. It would not deny Quebec's right to invoke Section 33, but it would deny Quebec the right to prevent the court from fully informing the public about the very different vision of equality and religious freedom enshrined in the Charter and letting the voters decide. Thank you.
Thank you so much, Bob. Again, you left us with a lot to think about there. And last but certainly not least, I'll turn it over to Professor David Dyzenhaus, who's a leading authority on the rule of law, also the editor of the University of Toronto Law Journal, to which Bob just referred. And I think David might pick up some of the threads that Bob laid out.
Thank you very much, Jutta. The two articles about which Bob spoke are both very dense and close readings of the Charter and relevant jurisprudence. And I was very pleased that we published them in the University of Toronto Law Journal, but they do make one's head hurt a bit. And I wanted to say something about what maybe lies behind the articles. So I'm not going to talk about Section 33 for the moment. I'm going to talk about a decision by the Supreme Court in Frank in 2019. This case concerned the right of all Canadian citizens to vote, the legislation that says that if you've been resident outside of Canada for more than 5 years, you no longer can vote. The majority takes this as a straightforward limitation of the right to vote and then asks the standard question, is that limitation justified in terms of Section 1 and Oakes and all of the rest? The dissent by Justices Brown and Cote is very different. And indeed, if one looks at the Chief Justice's decision for the majority, he was taken rather by surprise by this dissent because the position which the dissent adopts was not argued for by any of the parties before the court. That position is one that's becoming increasingly popular. It's called common good constitutionalism. And in a nutshell, common good constitutionalism says there's a set of natural laws that hover above the positive law. The Charter is just one articulation of these of these natural laws. Courts may try to articulate what these natural laws specify, but the legislature is actually the best institution when it comes to articulating what these natural laws require. This argument relies on work by Canadian legal scholars, Gregoire Weber at Queen's, Bradley Miller, who used to be at Western, who now on the Ontario Court of Appeal, and one non-Canadian, Richard Eakins, who's a professor of law in the University of Oxford. And in their articulation of this common good constitutionalist position, something rather strange happens. This was pointed out by someone who's a graduate of our law school, Tom Hickman, one of the leading human rights lawyers in the United Kingdom today, in a review of Gregoire Weber's book in the Modern Law Review in 2012, where Tom argued that even if we have a Bill of Rights that states that we have a right to a fair trial, legislation that gravely restricted the rights of the defense would have to be regarded as necessarily compatible with and indeed defining what our rights to a fair trial are. And indeed, with the right to vote, I think on the reasoning of Justices Brown and Cote, if the legislature restricted our right to vote to people who had PhDs or to people who owned a certain amount of property, that would be fine because that would be a specification of the right. Now, I think that if one goes from this kind of view to Section 33, then Section 33 becomes completely redundant, as has indeed been argued by three young Canadian lawyers. Why? Because when the legislature enacts legislation, it's specifying our rights, not overriding any rights. And I think that the reason why Gregoire Weber spends a whole lot of time making a very careful argument, which in a way saves Section 33, doesn't make it entirely redundant, is that he's trying to make it clear that there is an understanding of the text which is consistent with common good constitutionalism, and so it doesn't make it appear completely redundant. Now, of course, common good sounds great. Who could be against the common good? But what is the common good? There is something that Gregoire Weber, Bradley Miller, and Richard Eakins have in common. That is, their supervisor was the Oxford natural lawyer, John Finnis. I should mention that I was also supervised by John Finnis, but I'm not a common good constitutionalist. And what is common good constitutionalism? It is about a view whereby the ruler promulgates a common good for a particular political community. What is the inspiration for common good constitutionalism? We'll be told by Finnis that it's something called the classical tradition. The same claim is made by Adrian Vermeulen, the leading common good constitutionalist at Harvard University. But in fact, their real inspirations are not Aquinas, as far as I can tell, but two mid-century German thinkers, for Vermeulen, Carl Schmitt, and for Eric Voegelin, and for Finnis, just Eric Voegelin. Who were these people? If you want to find out more about them, you can put my name into a Google search with Voegelin and or Schmitt, because I've written several polemics on the internet about these folk. They were both fascists, they were both racists, and they hated liberalism. Mm-hmm. They wanted to put in place a society in which the ruler would promulgate a vision of the common good for a particular community, untroubled by democracy and the rule of law. Now, I don't for a moment think that Justices Brown and Cote are against the rule of law, against democracy, against liberal rights and freedoms, nor any of the authors whom I mentioned. But there is something odd going on here, and it's not what people might think is guilt by association. It's guilt by adoption. And what I would beg those who are putting forward this understanding of common good constitutionalism, including justices on the Supreme Court of Canada, is that they would investigate a bit more what the implications of the position are that they're adopting, because I think that position might take us down a path which none of us want to go down. Thank you.
And here I manage on the final leg to not notice that I'm muted, but here I am. So I think we have had a really rich spectrum of views, from some very specific observations about the particular uses of the notwithstanding clause, all the way to a bigger picture, and some really quite potentially dramatic implications. We've tried in the Q&A to answer a lot of the questions that came in. I fear that because we are very close to the end time of the panel, that we won't be able to deal with questions through a sort of Q&A here in the panel. That is a shame, because I have to say, even in the registration, there were at least, I don't know, 20, 25, 30 questions that people put to us. And that suggests that this is really a topic that has captured people's attention, and that a lot of people are concerned about from one perspective or another. So I would encourage you to continue the conversations. And I know that for us here at the law school, we will absolutely do that. And I want to thank all of the panelists who were here offering their perspectives today. Thank you very much. And doing that within the tight confines of 7 minutes is no small feat. So extra bravo for that. And thanks to the audience for joining us here today.